Namaste. This is Nandan Kumar. Again welcome you all in my YouTube channel Justice and Peace. I hope you are doing well and safe there. In this video I am going to tell you that how a foreign national can get married in India and what kind of documents they need for marriage. Before starting this video, I would like you to subscribe my channel so that you don't miss any important video. Due to lack of information in this regard, definitely you would find problems in your visa application, immigration or any other matter concerned to it. Consequently, rejection in your application, delay in matter, that increases your burden of proof and creates less chances to win. And I'm sure that you don't want it. Therefore, here I am to give you comprehensive information of how a foreign national can get married in India and what kind of documents they need for marriage. Watch the video till the end carefully and don't miss any content. Solemnization of marriage of a foreign national in India requires civil wedding. That means you have to follow certain legal procedures with valid documents. The legal procedures follows a lengthy process which takes 60 days approximately. I would like to tell you that when you plan for marriage, before you think about love, affection, compatibility, feeling of togetherness in your loved one to whom you want to marry, just because of you want to be with your soulmate for entire life and to avoid any fate or unfortunate events. Similarly, you must be also careful in your marriage ceremony, especially when you choose someone to marry in a foreign country. Sometimes the people in a hurry don't see the legal procedures and become a prey of an impostor, fraudulent, or even a legal professional who are just there to dump your money in the pretext of doing your work, who make you sure that the work will be done as per your requirement without following legal requirement. In such case, you do wrong with yourself as to your future planning and perspective. Being a qualified legal professional, I would suggest you must be careful when you plan to marry in India. There are 5 different acts which determines the procedures for marriages under different religions in India. The interested party to marriage, who are Sikh, Hindu, Jain, Buddhist, have to follow the provisions of Hindu Marriage Act 1955, which governs the marriage between them. Similarly, Indian Christian Marriage Act 1989 for Christians, the Muslim Personal Law Shariat Application Act 1937 for Muslims, the Parsi Marriage and Divorce Act 1939 for Parsis, and lastly, the Special Marriage Act 1954 for those who have no religious restriction for their marriages. The Central Information Commission has explicitly clarified in the Special Marriage Act 1954 that if a bride or a groom belongs to different religion or countries, they have to marry under Special Marriage Act, as they are not permitted to marry under personal marital laws. Some people may not desire to perform marriages as per their religious customs or restriction and prefer marriage under Special Marriage Act. However, a foreign national can get married under religious marriage ceremony in India, but they have to perform all customs and rituals of the religion they chose for marriage, such as walking around the fire and exchanging garlands under Hindu religion, which is governed by the Hindu Marriage Act. Adopting another religion means you have to convert yourself with your true intention, faith or belief into the religion you choose for marriage, as its customs and rituals required to be performed by the parties for marriage between them, as the Law Commission Report 235 emphasizes on it. Although such religious marriage is legally valid in India, but not a documentary evidence to prove such marriage. Therefore, Indian government requires marriage registration after marriage from the concerned marriage registry office. Marriage registration is mandatory under Indian law for any marriage, whether the marriage is religious wedding or civil wedding. As in 2006, the Supreme Court of India has recommended compulsory registration of marriage regardless of religions. Marriage registration is a civil marriage ceremony which involves a length of time, legal procedures and valid documents. Marriage registration is not enough to prove your valid marriage, but you must have the marriage registration certificate to prove your valid marriage. The marriage certificate helps you in your visa application and immigration matter, especially when you apply for spousal visa or green card, etc. The marriage certificate is valid until a divorce decree is obtained. It means there is no expiry date for marriage certificate. In India, the legal age for getting married is 18 years for girls and 21 years for boys. The same legal requirement extends to a marriage with a foreign national, irrespective of their own country's domestic law, which may prescribe higher or lower different age group for marriage. There are three basic requisite conditions for a marriage of a foreign national in India under the Special Marriage Act 1954, which require that: Number 1. Neither of the parties to the marriage who are seeking to marry one another is to have a living spouse. It means the interested party to the marriage should either be unmarried, divorced or widowed. Number 2. Neither of the parties to the marriage is incapable to giving a valid consent to it in consequences of unsoundness of mind, nor has been suffering from mental disorder or insanity, which unfits for marriage and the procreation of children. It means the parties to the marriage must have sound mind and are capable of entering into a marriage mentally with their free consent. Here free consent means the consent of the parties is not obtained by deceit, under pressure or undue influence. And the last, number 3. The age for marriage must be of 21 years for male and 18 years for female, but not below, as I've said before. In the Special Marriage Act, there is a 30 days residency requirement, which means either the bride or the groom has to be living in India for at least 30 days before applying to the concerned marriage registry office to get married. Residency of at least 30 days for either of the parties to marriage is a requisite condition before providing the notice of intended marriage. The foreign national can get the residency proof from the concerned local police station where they stayed in India for 30 days. Here the term concerned marriage registry office or police station means the office or police station which has jurisdiction to include the area or place where the interested parties to marriage have lived for 30 days. Further legal requirement is to submit the notice of intended marriage to the concerned marriage registry office along with evidence of residency that must be of 30 days, certified copies of your passports, birth certificates and 2 passport size photographs each. This legal requirement is only necessary for one of the parties to marriage. It means either the bride or the groom can present the intention to marry, but the notice must be signed by both the parties. Further, evidence of eligibility is another legal requirement to get married. It means the foreign national, whether bride or groom, who has not been married should obtain a single status certificate if the foreign national is an American, a certificate of no impediment if the foreign national is a British, certificate of no record if the foreign national is an Australian. Similarly, a foreign national who is coming from other country they have to produce similar document prescribed under their local domestic norms. If you are divorced, you'll have to produce decree absolute, that is a divorce decree. And if you are widowed, a copy of death certificate of your deceased spouse. Additionally, a no objection letter is required from the foreign national who wants to marry in India. The foreign national can get the no objection letter from his/her embassy or consulate in India. There must be a question that who is the eyewitness of your marriage. Therefore, under legal requirements, 3 witnesses are required for the marriage, in which they have to give their passport size photographs along with IDs and address proofs. During the court marriage, a declaration is to be signed by both the parties along with 3 witnesses declaring that the parties are entering into marriage with their free consents. After receiving the notice of intended marriage with all requisite documents, the marriage officer publishes the notice in his office or might even in a newspaper if necessary for any objection. If a person has an objection to the marriage, he or she is allowed to raise the objection within 30 days from the date of publication of the notice. If there is no objection to the marriage, then the marriage takes place and the marriage registry office provides marriage certificate to the couple. The marriage certificate is valid for your all legal requirements. The marriage registry office takes 30 days approx after filing the all requisite documents to complete the marriage. Generally, the marriage certificate is issued within couple of weeks after the wedding. Aforesaid information is very crucial for your marriage, so don't miss any paper while you go for marriage, which are required in your civil marriage ceremony in India. These documents are very crucial, so that's why here again I am going to tell you the all required documents. So let's see again. These documents are notice of intended marriage signed by both the parties, receipt of fees paid along with the notice, birth certificates of both the parties for age proof, affidavit of written statements of consent of both the parties to marriage along with the statement affirming that the parties are not related to each other under the probative degree of relationship, residential address proofs of both the parties in India, a valid visa of more than 30 days for the foreign national, a certificate of single status or similar other documents as per foreign national countries' domestic laws, decree absolute for divorcee, death certificate for widowed, passport size photographs, documentary evidence of 30 days residence in India, and a no objection letter from the embassy or consulate of the foreign national's country. I am sure that this comprehensive information in respect of a marriage of a foreign national in India will be very helpful and beneficial for your all legal requirement concerned to it. Lastly, I would like to say that if you have any query or need any information in this regard, ask me or comment with your valuable feedback. And if you like this important video, please like it and share it. And don't forget to subscribe this channel so that you don't miss any important video. Namaste.